In my last video commentary, looking at the controversy that led to the firing of John McCallum as Canada's ambassador to China, I took aim at China's pressure campaign against Canada. This campaign is clearly designed to bully us into a political retreat from our arrest of Huawei telecoms CFO Meng Wenzhou on an extradition warrant from legal authorities in the United States. We were being punished by China, I argued, for, in effect, not being China, where the Communist Party is indisputably above the law. As I said then, the Chinese, unlike Canada, do not have the rule of law. If the communist rulers of the People's Republic have a view about who should be prosecuted, when and why, and about what sentences should be handed down, they simply issue orders to the police and the judiciary. That's not how it works in Canada. We have labored mightily to keep political interference out of the legal system. If a government official tries to call a judge to tell him or her what the government's preferred outcome in a court case is, it would be a scandal. The Chinese dismiss this as window dressing. They do not accept that Canadian politicians cannot simply issue orders to any part of the state's machinery, including the police, the prosecution, and the judiciary. In China, the Communist Party is above the law. In Canada, happily, no one is. Or at least so I thought. The reason I began to question this assumption, and why I am sure the Chinese are gleefully going to double down on their campaign against us, is because of the stories leaking out of Ottawa to the effect that officials at the very highest level of government, the Prime Minister's office, may have intervened in a proposed prosecution of a Canadian company, SNC-Lavalin. Very quickly, the story is this. SNC got into trouble nearly a decade ago for bribery and corruption in some of its foreign dealings, and this behavior has been alleged by federal prosecutors to violate Canadian law. Because conviction on these charges would result in a 10-year ban on the company bidding on federal projects, the chief source of SNC revenue, the company has been waging an energetic campaign to replace a criminal prosecution with a negotiated remediation agreement. Such an agreement would cost the company some money, but avoid the bidding ban, thus safeguarding SNC's business model. To the company's consternation, federal prosecutors were not interested in playing ball, but rather rejected the remediation route and planned to proceed with a prosecution. The potential scandal brewing in Ottawa revolves around the question of whether the Prime Minister's office attempted to intervene with the then Justice Minister, Jody Wilson-Raybould, to press her, either directly or indirectly, to order the prosecution to stand down in favor of remediation. To date, the government's response, which is stonewalling of the highest order, only fans the flames of suspicion that there is some truth to these rumors, especially given that SNC has admitted illegally funneling money to the Liberal Party in the past. This impression is further reinforced by the Prime Minister's refusal to date to waive client solicitor privilege and authorize Ms. Wilson-Raybould to speak candidly and publicly to confirm or deny what pressure she may have come under and whether her recent surprise demotion to Minister of Veterans Affairs might be related to her determination to respect the rule of law and refuse to overrule the decisions of her independent prosecutors. So far, her silence seems eloquent. Add to that recent reports from MLI detailing the breathtaking scale of Chinese money laundering activities here, with an apparent inability to prosecute successfully such crimes, and the bizarre prosecution of Mark Norman, the number 2 in the Canadian Forces, in a case centering around allegations of political interference in military procurement at the behest of corporate interests, and Mr. McCallum's defense of cutting a political deal to release Ms. Meng from the clutches of the Canadian court system, and a disquieting pattern begins to emerge. Distressingly, it is a pattern that suggests that Canada is only a country where the rule of law prevails when it is in the interest of public authorities that it do so. That's the system that prevails in China. If we don't dispel that impression, and forcefully, Beijing will legitimately wonder why Ms. Meng is being subjected to the rigors of the law, but not other Canadian business interests who can use a political get-out-of-jail-free card. The new Justice Minister, in his first interview, was at some pains to point out that when the courts have finished examining the extradition case against Ms. Meng, he still has discretion to refuse to authorize extradition, including on grounds that to proceed would be contrary or damaging to Canada's foreign policy. This does not sound at all like a government committed to the rule of law, but rather one signaling to Beijing that a political deal may be in the cards despite all the huffing and puffing about the rule of law. Beijing, like Canadians, is watching closely to see what kind of a country we really are after all. I'm Brian Lee Crowley for the Macdonald-Laurier Institute.